That's all you deal in is debt. You don't deal in, there is no money.
Mr. Ingres, if you'd come up, sir, and stand beside Attorney David Al.
John Ingres is in the court. That's you. Before we go any further, I need to know who you are.
I am
Clerk.
Judge Crocker, right here.
Thank you, Clerk. Are you the CQV trustee who has appointed this judge as administrator and trustee of the constructive trust, case number 458-2010-CR-01203?
Mr. Attorney David Al, your motion for competency evaluation is granted.
And I'm appalled at what I see happening in this country today. We are told that America is the land of laws, a nation built on laws. In point of fact, nothing could be further from the truth. America is run by people who are lawless. We have no law in America, and understand that. The law is whatever the powers that be in power happen to say it is today. Whatever they say it is, that's what the law is today. And it may change tomorrow.
Of the people or the corporate United States?
It's in favor of the banks. It's certainly not in favor of the people. What happens when you have a child is your child is given a Social Security number. They estimate how many taxes your child is going to pay over his or her lifetime. And they take that birth certificate and they issue it on the capital markets and they earn money on it.
Let me tell you why you're here. You're here because you know something. What you know you can't explain, but you feel it. You felt it your entire life, that there's something wrong with the world. You don't know what it is, but it's there, like a splinter in your mind, driving you mad. It is this feeling that has brought you to me. Do you know what I'm talking about?
Matrix.
Do you want to know what it is? The Matrix is everywhere. It is all around us. Even now, in this very room. You can see it when you look out your window or when you turn on your television. You can feel it when you go to work, when you go to church, when you pay your taxes. It is the world that has been pulled over your eyes to blind you from the truth.
What truth?
That you are a slave, Neo.
I'm here by special appearance only under a full representation.
Call first, right?
Sure.
You're here on charge of failing life. You're also here improper passing. You're also here for tinted windows, no insurance, no seatbelt. How do you plead to those charges, sir?
I'm here by special appearance to challenge the jurisdiction, and furthermore, I don't understand the nature and cause of these proceedings, so I would like to ask a couple questions so I can properly be able to handle this matter.
So, I'll enter the pleas of not guilty.
I didn't enter that voluntary. I don't understand the charges, sir. Do I have the right to understand the nature and cause of these proceedings?
Sir,
I don't yet understand the nature and cause of these proceedings. Do I have that right, sir?
if you don't be quiet, I'm gonna lock you up.
The Sixth Amendment. The key to the fraud hinges on understanding the sixth article of the Amendment of the Constitution of the United States. The discussion begins with the text as follows. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The key words is the emphasized portions are all and shall. All implies that there is more than one criminal jurisdiction. Shall makes the enjoyment of the right to be informed mandatory. The information or indictment must state the nature and cause in plain language that is understood by the accused. Many victims accused of offenses against the state or United States have found themselves in prison and all their assets forfeited for lack of understanding of the nature and cause of the accusation. In the classic document Common Law Abatement by Don Quixote in the School of Law, Juris Doctorate, he shed some light on how the nature of the action was hidden from the public. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established, and the action was in the nature of administrative. Live people could not be brought into administrative courts, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement in the complaint of the nature of the action was lost. The attorneys all got together and decided that it would be much simpler for them if there were only one form of action. So today, there's no disclosure of the nature of the action, unless one demands to know the nature and cause of the accusation by using a demand for a bill of particulars.
And today's legal term is bill of particulars. This is factual detail submitted by a party upon request that further explains or clarifies the charges or allegations in a case.
Within the past couple of decades, they moved it to discovery, which is after arraignment, so the ability of one to challenge the jurisdiction and venue of the court was lost. This is because entering a plea accepts the jurisdiction. In this way, only subject matter jurisdiction was challengeable. If they say this is a matter at law, my defense against this jurisdiction is whether there is a live damaged party. I do not ask if this is an equity jurisdiction, because equity is not a criminal type of action. If they say this is a matter in hustings, which is the true nature of action of all administrative law, my defense against this jurisdiction is that I'm not an artificial person, unless I am a federal citizen, but that is quite another matter entirely. Unless they can show from the records in the Secretary of State's office that I have chartered as such. If they say that this is an Admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory over which the state has retained concurrent jurisdiction, although I've still not found how the state exercises an Admiralty jurisdiction in light of 28 United States Code subsection 1333. If they say this is a military matter, my defense against this jurisdiction is that, number one, I'm not a member of their military. I am, however, a member of the militia of the several states, but they do not operate as such anymore. And number two, the nation is not under martial law. Or is it? Given the fact that there are currently 14 notices from the presidents of a declaration of national emergency published in the Federal Register, we may very well be in a state of martial law. The one from March 6, 1933 is still in effect today. However, they are not going to admit the nature of the action, as this will admit their want of jurisdiction on the record for all to see. so they move to dismiss the charges every time. While I will never succeed in bringing down the current regime in this manner, at least other folks see what I'm doing, and some decide along the way that they want to learn this procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, that we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is clearly matter founded in law martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I am therefore unable to enter a plea to the charge until I have had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. The Supreme Court has held there are no common law offenses against the United States, only those acts which Congress has forbidden, with penalties for disobedience of its command, are crimes. Actions to recover penalties imposed by act of Congress generally, but not invariably, have been held not to be criminal prosecutions. Oceanic Navigation Company versus Stranham. Hepner versus United States versus Regan. Contempt proceedings, which are at one time not considered to be criminal prosecutions, are no longer within that category. Compare In re Debs, 158 U.S. 564, 1895, with Bloom versus Illinois. What is the nature of the accusation? If common law crimes against the United States do not exist, what kinds of crimes do exist against the United States? Article 3, Section 2 provides for 4 different jurisdictions: law, equity, admiralty, and maritime. By process of elimination, we can automatically rule out law by virtue of the above Supreme Court holdings. Equity is defined as justice administered according to fairness as contrasted with the strictly formulated rules of common law. The term equity denotes the spirit and habit of fairness, justice, and right dealing with which regulate the intercourse of men with men. See Black's Law 6th edition. Equity deals with fictions like corporations. Since it is common knowledge that law and equity have been combined and are virtually indistinguishable from each other, and that anyone who has witnessed criminal proceedings in the courts easily recognizes that these criminal or quasi-criminal accusations are most usually contrary to the spirit and habit of fairness and justice and right dealing of men with men. Therefore, the cause of action cannot be inequity. Admiralty is defined in Bouvier's 1856 edition as the name of a jurisdiction which takes cognizance of suits or actions which arise in consequence of acts done upon or relating to the sea, or, in other words, of all transactions and proceedings relative to commerce and navigation and to damages or injuries upon the sea. Black, 6th edition, observes that the terms admiralty and maritime are virtually synonymous. Bouvier's 1856 edition defines maritime cause as 1. Maritime causes are those arising from maritime contracts, whether made at sea or on land. That is, such as relate to the commerce, business, or navigation of the sea, as charter parties, affreightments, marine loans, apothecations, contracts for maritime service and building, repairing, supplying, and navigating ships, contracts and quasi-contracts respecting averages, contributions, and jettisons, contracts relating to maritime insurance, and those between owners of ships. 2. There are maritime causes also for torts and injuries committed at sea. 3. In general, the courts of admiralty have a concurrent jurisdiction with courts of law of all maritime causes, and in some cases they have exclusive jurisdiction. As long ago as 1851, the Supreme Court recognized that the Congress has the power to extend the jurisdiction of admiralty and maritime causes to the land under the Commerce Clause and deprive the people of the right of a trial by jury. The following holding by the High Court pretty much says it all. This power of admiralty jurisdiction is as extensive upon land as upon water. The Constitution makes no distinction in that respect. And if the Admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. And it may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, and over the persons engaged in conducting them, and deny to the parties the trial by jury. Now the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. The very next year in 1852, the Supreme Court warned that this admiralty or maritime threat to liberty was encroaching on the land and morphing itself in an air-breathing creature, just as a harmless tadpole transforms itself into a frog. And this is a really ugly frog. If you had never seen a tadpole gradually go through this miraculous process, you might never believe that such a transformation could occur, changing a harmless water-breathing creature into an air-breathing predator. Next to revenue, taxes itself, the late extension of the jurisdiction of the Admiralty are a great grievance. The American courts of Admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the Admiralty. Jackson versus Magnolia. Has the Congress expanded this admiralty and maritime jurisdiction? The answer is a definite and emphatic yes. One only need to examine the codification of Title 18 of the United States Code, Section 7. The broad language of Title 27, Code of Federal Regulations, Part 72.11, makes almost all crimes, whether or not they are federal or state crimes, commercial crimes. In the Propeller Genesee Chief Supra, it was revealed that Admiralty courts have jurisdiction over interstate commerce. So it would follow the crimes listed in 27 CFR 72.11 are cognizable in an Admiralty or maritime court, and such are commercial courts. The relevant part of the text is as follows. Commercial crimes. Any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame and like offense, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. In the Ebsworth and Ebsworth Lecture of 1994 Infra, Proctor Winswall states, Congress has been repeatedly held by the court to have the power to extend the admiralty and maritime jurisdiction by statute, and Congress has repeatedly exercised that power. What many of the victims accused of maritime crimes don't realize is that admiralty and maritime jurisdictions were merged with the law and equity jurisdictions in 1966. See Federal Rules of Civil Procedure, notes to supplementary rules for certain admiralty and maritime claims. All four causes of action, or natures of the cause, which were once separate and distinct, are now rolled into one set of rules and indistinguishable from one another in our modern courts. Federal Rules of Civil Procedure, FRCP Rule 1, provides that the rules govern the procedure in the United States District Courts in all suits of a civil nature, whether cognizable as cases at law or in equity or in admiralty, with the exception stated in Rule 81. Rule 2 provides that there should be one form of action to be known as civil action. Federal Rules of Civil Procedure Rule 9H provides in part, if the claim is cognizable only in Admiralty, it is an Admiralty or maritime claim for those purposes, whether so identified or not. Federal Rules of Civil Procedure Rule 38E provides that these rules should not be construed to create a right to a trial by jury of the issues in an Admiralty or maritime claim within the meaning of Rule 9H. Well now, aren't the rules revealing? Maybe this explains why the judge can amend or reverse a jury verdict or even jail the jurors for contempt if they don't do what the judge tells them to do. It has happened. The jury is just there for window dressing to make the sheep think that there is a trial by jury. Law, equity, admiralty, and maritime, the once separate and distinct jurisdictions, are now neatly rolled into one set of rules, tried in the same courtroom with the same judge on the same docket and with nothing to distinguish the different jurisdictions from one another. If the criminal accusations that plague Americans today are not in the jurisdiction of common law or equity, they must be in admiralty or maritime jurisdictions. And though admiralty and maritime jurisdictions are virtually indistinguishable, Bouvier's definition of a maritime cause as those arising from maritime contracts, whether made at sea or on land, fits the bill. For the sake of illustration, let's take time to consider the condition of military personnel. When a young man enlists in the armed forces, he signs an enlistment contract that binds him to the law of the Code of Military Justice. This Code of Military Justice cannot apply to civilian folks who are not contracted. Under the Code of Military Justice, the accused is guilty until proven innocent. If the accused wishes to defend himself, he is put into the position of trying to prove a negative, a virtual impossibility. In other words, he is put into the position of proving that he did not do something. The military court or court-martial, where these military cases are tried, is a legislative criminal court established under the legislative power of the Congress to regulate the armed forces. Their jurisdiction is entirely penal. An action upon a penal statute is defined as an action for the recovery of a penalty given by statute. In a broad sense, the term has been made to include all actions in which there may be a recovery of exemplary or vindictive damages, an action in which the judgment against the defendant is in the nature of a fine or is intended as a punishment, and disciplinary. The word penal is inherently a much broader term than criminal, since it pertains to any punishment or penalty and relates to acts which are not necessarily delineated as criminal. Military personnel are subject to court-martial penalties because they are under a maritime contract. Did you ever notice that Texas has a code of criminal procedure, but not one criminal law? That's right, there is no criminal code and not one criminal law in Texas. But there is a penal code that is just chock full of offenses, and more being added every time the legislature convenes. And if you have done battle in the Texas court system, you'll have noticed that the courts don't follow the code of criminal procedure very well. If you make enough noise, they will give it a little bit of lip service, but the judges mostly ignore it. The courts have held, power of punishment is vested in the legislature, not in the judicial department. It is the legislature, not the court, which is to define a crime and ordain its punishment. U.S. versus McLean. The legislature may declare that the doing of certain acts shall constitute the offense of sodomy and may ignore, if it sees fit, the common law elements of the offense. Slusser versus State. Under Texas law, no act or omission is a crime unless made so by statute. Dawson versus Vance. Black's Law 6th edition defines a penal action as a civil action in which a wrongdoer is subject to a fine or penalty payable to the aggrieved party. The word penal is inherently a much broader term than criminal, since it pertains to any punishment or penalty and relates to acts which are not necessarily delineated as criminal. Action is essentially penal if amount sought to be recovered is arbitrarily exacted for some act or omission of the defendant. The legislature may create an offense and in same enactment provide exceptions to its application. Williams versus State. In summary, and according to the courts, the legislature defines crimes, can create a crime while ignoring the common law elements of a crime and mandate the punishment for the crime it creates. There is no crime unless it is created by the legislature. All of this certainly flies in the face of the common law rule that there must be an injured party for a crime to exist. These creations of the legislature are most certainly maritime crimes. In Howard Freeman's The UCC Connection, he explains why the courts are hiding the Admiralty jurisdiction from the general public. He states that the reason they cannot call it Admiralty jurisdiction is that your defense would be quite different in Admiralty jurisdiction from your defense under the common law. In Admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know it is Admiralty jurisdiction, and you have admitted on the record that you're in Admiralty court, you can demand that the international maritime contract to which you are supposedly a party and which you supposedly had breached be placed into evidence. No court has Admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb, well, I didn't know that I got involved with an international maritime contract. So, in good faith, I deny that such a contract exists. If this court is taking jurisdiction in Admiralty, then pursuant to Section 3-501 of your UCC under presentment, the prosecutor will have no difficulty placing the alleged contract into evidence so that I may examine and possibly challenge the validity of the contract. What they would have to do is place the national debt in evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves.
You'll hand us. You know your predecessors had much more respect. Okay, you have some skill.